Today's topic is administrative law. My name is Umesh Rao. Contents are meaning and definition of administration law, scope of administration law, nature of administration law, growth of administration law and growth of administration law in India, and reasons for the growth of administration law. Now, what is administration law? What is the meaning of administration law? It is a law relating to the administration. It determines the organization, the powers and duties of the administrative authorities. They are executives. They are government officials. So it is the subordinate branch of constitutional law. Is there any source or base for administration law? There is no source or base for administration law. Administration law is unwritten law, it is uncodified, and it is judgment law. There are so many codified, written, well defined law like Contract Act, Penal Code, Evidence Act, Constitution of India, and Transfer of Property Act. But administration law is not like that. It has developed slowly with the passage of time. Here, authorities are called upon to perform not only the executive functions but also quasi-legislative and quasi-judicial acts. Now, we will go for the definition of administration. As per Casey Davis, administration law is the law concerning the powers and procedures of the administrative agencies. As per Robson, administration law is the governing the administration. As per Garner, administrative law contains those rules which are recognized by court as law and regulates the administration of government. As per Jennings, administration law is the law relating to the administration. It determines organization, powers and duties of the administrative authorities. So administration law, as per Jennings, subdivided into three parts. One, powers vested with the administrative agencies and requirements imposed by law and remedies against unlawful administration. Now, scope of administration law. Administrative law is the gift of the 20th century. It is the outstanding development of the 20th century. Before 20th century, all the powers were vested with the king and group of people. So, role played by the state is also very important. King's function was very limited. He has to maintain law and order, and his duty is to collection of revenue, and he has to protect the state from enemy. But during the 20th century, there was change. The police state changed into welfare state. There are many functions to be undertaken by the government. So legislatures cannot do all these functions, and this led to the growth of administration law. In 20th century, there is a big change. What is it? The British rule three-fourths of our world. This East India Company, it is a trading company and it is a joint stock company. The purpose of the company is to trade with East Indies. The company was started and it was granted an English royal charter under the name of the governor by Queen Elizabeth on 31st 12 1600. The East India Company ruled India for 250 years till 1958. After first Indian independence war, British Crown had taken the power from East India Company and rule of East India Company ended. Now all the acts of the East India Company is nothing but the administrative activities. They derived authorities from Queens. And second reason is the industrialization. Due to the industrialization, new class, working class, labor class started. People started from migrating from rural areas to urban areas. They want house, they want housing, they want shelter, they want food, they want education, they want health. All these facilities cannot be given by the legislature. So, administrative authorities are required to provide all these things. And development of science and technology is another reason for the growth of administrative law. Growth of population in the world. World population improved, increased. So population, due to the population, there is a food problem, there is the education problem, there is a housing problem. All these problems were came. So development of literacy, the expectation, the literates expectations in the world is increasing, and that is also a reason for the growth of administration law. Establishment of democratic countries in the world is another reason for the growth of administration. So, establishment of League of Nations and United Nations organizations is also another reason. So, political awareness among people increased. So, due to all these changes, countries adopted the concept of welfare state. Police state was changed into welfare state. All people should get food, clothes, and shelter. So, concept of equality includes economic equality also. All men and women should get adequate means to livelihood. The ownership and control of material resources of the country shall be distributed to the common good of the nation. All these functions must be carried by the executives or bureaucrats. It is a separate branch of law. The nature of administration law. You know that government has three branches. One legislature, second judiciary, third executives. What is the function of the legislatures? Parliament has power to make law, or state legislatures has power to make law. Judiciary, High Court or Supreme Court has judiciary powers. Executives, they are administrators, they has power to implement the law. So, this law is made by the parliament and it is implemented by the administrators, and if dispute arises in the law, it is interpreted by the Supreme Court. This is the first nature. So, the government is functioned under three branches: legislature, judiciary, and executives. So, second one is the doctrine of separation of power. You know that judiciary, legislative, and executive, three powers are there. Here, what is the theory of separation of power? The parliament will not interfere in the matters of the courts and administrators. The court will not interfere in the matters of the legislatures and administrators. The executive will not interfere in the matters of the legislative and judiciary. This triangle relationship is called the doctrine of separation of power. But another thing is the rule of law. The executive must follow the rule of law. What is the rule of law? It is the absolute supremacy of law, and all are equal before law. So, predominance of legal spirit. Absolute supremacy of law means King and employees all are below the law. Law of the land is supreme. The men are ruled by the law and law alone. Law gives equal justice to all. There are no separate courts for officers and government. And predominance of legal spirit. Personal liberty is guaranteed under the written constitution. If man is wrongly arrested, he can file a suit. So no arbitrary powers. These are all the important features of the rule of law. The parliament can delegate some of the power to the executives for speedy implementation of infrastructure and social welfare activities. It is called delegated power. Now, these administrative powers are always the preventive functions. For example, maintenance of law and order, issue of licensing, rate fixing, grant of fair price shop owners dealership, and granting labor license and granting permission to constructions. So the authorities possesses administrative powers and quasi judicial powers. It is necessary part of life in the welfare state. So legislations made by the parliament is rigid. The delegated legislations is flexible. For example, labor problem like lockout, strike, dispute, it is brought before the labor court or labor officers and not before the parliament. So administrative tribunals and industrial tribunals, they are not required to follow rigid procedures. They are flexible. So administrative authorities are make rules, orders, regulations and bylaws, etc. Another feature is the writ of mandamus, certiorari, prohibition and habeas corpus issued by the court against the administrative authorities if they violate the principle of natural justice and fundamental rights. But tribunals have no power to issue writs. The growth of administration law. Administrative law can be traced to the well organized and centralized administration under Mauryas and under Guptas. It is before the birth of Christ. So administration system was introduced even during Mughals period also. Administration system was there under East India Company also. So administrative law has grown and developed tremendously in quality and quantity in the 20th century. In the present century, it assumed a more recognizable form. The political philosophy of the 19th century was laissez-faire. This means individual enterprises, self-help, maximum free enterprise and minimum government control. States' responsibility is only to maintain law and order. But during the 20th century, social and economic policies of the government has significant changes and it has impact on the private lives of the citizens. For example, government has to provide housing, government has to provide employment, government has to do planning, government has to give education to all citizens, government has to take care of health, government has to give service to the people, government has to give pension. These are all the important functions of the government and this resulted in the delegated legislations. During the Second World War, the executive powers increased tremendously. After independence, the activities of the government has further increased and social security measures taken by those who employed under Industrial Disputes Act 1947, Minimum Wages Act 1948, Factories Act 1948, Employees State Insurance Act 1948, all these were introduced. The philosophy of welfare state came into existence, the ownership and control of material resources of the society should be distributed to serve the common good. State is given power to improve. State is given power to impose reasonable restriction to the public. What is the reasons for the growth of administration law? You know that? Administration law, radical change in the philosophy of the state, role played by the government. Previously, the state, the policy of law and order and laissez-faire was given. Previously, king was there. He has got very limited powers, very responsible, limited responsibility. He has to protect, he has to give protection to the people. He has to take care of people from enemy countries. But afterwards, the policy of law and order and laissez-faire was given up. State is not confined to the minimum function of the defense and administrative functions. Welfare state has undertaken to perform functions. Second one is, due to the industrial revolution in England, factory system emerged and search for employment in factories and large scale of industries. People migrated from rural areas to the urban areas. There is a need for increasing housing, road, parks, drainage system. Accordingly, authorities were required to make rules and regulations. This led to the growth of administrative law. Third one, to meet the emergency situations. Normally, enacting legislations is a lengthy process. Getting approval from the president was not easy. It was very easy and quick to frame schemes and rules that arise in that locality. There is a flexibility in making the rules. All this led to the growth of administration law. Next one is the judicial system. Judicial system proved costly and inadequate, and it is very slow and it has complex problems. It was not possible to expect speedy disposal of important matters like disputes between employees and employers, lockouts and strikes. So therefore, industrial tribunals and labor courts established the solve the complex problems. And legislative process was inadequate. Legislature had no time and technique to deal with the problems. It was impossible to leave a detailed rules of the procedures. The law made by them found to be defective and inadequate. And next one, sometimes the rule requires to be made on experiments and basis of experiments on administrative process. A rule can be made and tried and altered and modified within the short period. The legislation was rigid in character, and administration law, it is very flexible, and we can change and we can amend, we can modify and we can revoke also. So administrative authorities can avoid technicalities. Administration law represents functional, but traditional judiciary is conservative. It is not possible for the courts, it is not possible for the court to decide the cases without formality. But administration law is not like that. Administration law are not bound by the rules of evidence. They can take a practical view. Last one, administration law can make preventive measures. They need not wait for the parties to come before them in case of licensing, rate fixing, etc. Administrative authorities can take steps for suspension of license, revocation of license, cancellation of license in their hand. In recent times, global administrative law is also emerging. World Trade Organization is dictating guidelines. All these points causes growth of administration law. This is an end.